President Muhammadu Buhari's recent demand for expedited confirmation of his latest ambassadorial nominees and the new service chiefs has been referred to the relevant committees by the Senate leadership. The ambassadors in waiting consist of former military chiefs whose tenures are still a matter of intense public scrutiny and debate, owing to obvious weaknesses in their handling of the war against terror. Joining us now from Arise Abuja studio for a conversation around this and the reconfiguration of the political space ahead of the 2023 general election is Daniel Bwala, a lawyer and member, Lincoln's Inn, London, UK. Welcome to the program. Good morning.
Good morning. Thank you for having me. Thank you, Dr. Abati, Mr. Rufai, and my learned colleague, Todo.
Thank you very much for joining us, Daniel Bwala. Well, quickly, let's treat some of the topical issues, some of which we've been focusing on. Now, a federal high court has taken the decision, the Court of Justice Mohammed, to direct that those accounts of the NSAS protesters that were frozen in 2020 should be released. And then, of course, some of them have said they will go to court because they think that this has been an act of intimidation on the part of the Nigerian state. And then, of course, there's been a comment from the Attorney General of the Federation on how nobody can intimidate the federal government of Nigeria or compromise the rights of the federal government under the 1999 Constitution. Could you please help us, explain this, both from the civil society perspective and the legal perspective?
Well, thank you for having me. Well, by my discipline of law, I try to look at it basically from the foundational level, which is the law, whether or not the order of the court is binding on the federal government. Under the doctrine of separation of power, we have the three arms of government. The judiciary stands to interpret the law. And if the court delivers a verdict, usually the verdict will favor one side and will not favor the other. Another day, the order may favor the other party and not favor the other. But the law is that once the court delivers a verdict, unless and until the verdict is vacated or there is an appeal which overturns that verdict, however wrong it stands as subsisting and must be obeyed by all authorities throughout the Federal Republic. If you look at the judicial powers of the government, they say their power extends to all courts and decisions are binding on all authorities. So the order of the court, I do not think amounts to intimidation of the federal government, because before the court arrives at that order, the court must have heard both parties. And even if it is an ex parte application, then the other party, through the application on notice, will get the opportunity to have that issue trashed out. So I do not want to come into the political side to it, but I know that the order of court is to be obeyed, and the number one person to remind the government that the order ought to be obeyed is the Attorney General of the Federation, but not to say that the order amounts to intimidation of the government. Because if the court delivers a verdict in support of the government, I'm sure even before the press will carry the news, the government would have used the apparatus of the state to enforce it. So, and the judgment of court can go either way. You have the right to appeal against that order, but until the appeal is determined or the same court vacates that order, it is subsisting and it is binding on the federal government to obey that. That is the rule of law in a democratic society.
Well, both the opposing counsel did reach some kind of consensus with regards to that case, but I wanted to talk to you about the registration drive and revalidation exercise that your party, the APC, is conducting at the moment. I trust that you have had your membership revalidated, but what does this mean in practical terms for Nigerians? This whole talk of the party going back to the grassroots and what have you. What's in it for us?
Well, the constitution of the party is clear about validation of membership. The constitution of the party expressly says that every 6 months, I think, the party will need to revalidate and verify the membership. And I think the idea behind the registration or revalidation of the membership stems from the view that some persons may have left the party, others may have joined the party, therefore the need for them to register. And then there are individuals who at the time, probably at 2019, they didn't attain the age of 18. And on this occasion they have, and therefore the need for them to register. It is something that should be welcomed, not just by our party, but by all political parties. Another side to it is that when you begin to create that awareness for membership registration, it gives room for the generality of Nigerians to see the pros and cons of being a part of that party. However, the legal conundrum is that I think it is better to say to verify than to say to revalidate, because the requirement of law is that you can only register once, you cannot register twice. If I have registered yesterday, I don't need to come and re-register today again. But you can verify by asking me to bring document, or probably my circumstance has changed since the last registration. Therefore, the need for me to come and produce this document so you can verify that. So it's a welcome development. However, it must be treated with caution. There are individuals who think that this membership registration is a strategy by others to take the party, to snatch the structure of the party. I do not think so. I think that you need to be a member to have a local standard to challenge decision of the party, assuming the party tomorrow goes contrary to what the constitution of the party is all about.
I mean, this leads me to the sentimental conundrum here, where the likes of Chief Bisia Konde have come out to say, what's all of this? What's this you're doing? It's a charade. Adams Oshomole said the same. Are you going to say these people speaking against this process, are you going to say it's just sour grapes on their part, or what is it? Because a lot of people are looking and saying, what are you doing, really? And these are key stakeholders in your political party. Well, doesn't it just increase the fault lines?
I am aware that before the 2019 election, we had membership registration. Then I did mine. And by the way, I have not done my revalidation because the constituency or rather the polling unit where I'm supposed to go and do my revalidation have not been given the necessary materials for us to do. But in a nutshell, in any political party processes, there is likely going to be one discontent or one complaint here and there. Let me put it this way. There is need for membership verification for the purpose of incorporating the three elements I told you about: people coming to the party and then striking out names of persons who have left the party, and then, of course, co-opting those who now have attained the age of majority to be able to join the party. But those who criticize that may have a valid point in the sense that if, for example, there has been a registration and you are trying to do another registration, some people can raise issues such as probably misuse of the funds of the party, or probably attempt to hijack the party processes. But strictly from the perspective of law and the constitution of the party, it says that every 6 months there is need for the party to do verification for the purpose of ascertaining members of the party going forward.
Well, Daniel Bwala, before we wrap this up, I'd like to take advantage of your presence to ask for your comment on the extension of the tenure of the former inspector or the Inspector General of Police. Briefly. Well,
I have heard a lot of legal fireworks. Some people say that the president does not have the right to extend the tenure of the former IG of police. Others say it does. But I know that from the perspective of law, the argument shouldn't be about appointment. It should be about whether the president has power. The powers of the president to appoint is quite clear, and from the way people have argued it, in 215, 216, and then the Police Act Section 7, and then some other subsidiary laws. But the question really, and the president actually complied with that at the time this former IG, or the IG of police was appointed. But now the president did say he's extending the appointment by 3 months. So the power to extend must be read in conjunction, that is to say 215(7) of Police Act must be read in conjunction with Section 5 of the Constitution, which gives the wider powers of the president regarding executing the Constitution. Does the president, under Section 5, has the power to execute the provision of the Constitution or to extend the powers of the police chief? I think the answer is in the affirmative. The complaint really should not be about extension, but about morality.
Well, thank you very much, Daniel Bwala, for joining us. Thank you very much.